O'Hara Fortune, cause numbers XD01744414 and 1A00333984. This is on for a motion for competency restoration. Before we get started, I've reviewed both councils' briefing on this issue, and I want to clear up a few things that I'm not sure if we're all on the same page in recognizing the procedural history here of how we got into this dispute about whether or not the court should order Ms. Fortune's competency restoration treatment. First of all, Ms. Fortune was previously represented by Ms. Kenneman, and before Mr. Fricks came on the case, defense counsel in December, we made a motion for a competency evaluation based on things that were happening in the court proceeding that day. The court signed that competency order as well as the prosecuting attorney. I'm not sure who actually prepared the order for competency evaluation. Typically, the prosecution does, but we've been doing electronic forms for COVID, so I may have prepared it at that time. Certainly, we all reviewed it and signed it, and at that time, the order for competency evaluation indicated that none of the offenses were serious offenses. So that's where the first miscommunication occurred, because the state believes that these are serious offenses, defense believes they're not serious offenses, and that should have been addressed when the order was the evaluation was ordered, because then the evaluators took that into consideration in making their recommendations. And if the court finds that this is a serious offense, I think we need to refer it back to the evaluators to make an opinion about the effectiveness of restoration treatment, etc. All the things that the evaluator would have put into their evaluation had this been checked off a different box. So that's just preliminarily the box. If the court were to find that this is a serious offense, then I think we need to address the initial order for competency evaluation. So then the evaluation was completed. Ms. Fortune was found not competent to stand trial at this point, and the state gave notice they did a file motion to order competency restoration. The statute for restoring competency in a non-felony case makes a distinction between serious and non-serious offenses, and that's where a majority of counsel's argument goes to. And in both cases, the presumption is that the court is going to dismiss the criminal charges and not order competency restoration unless, in a serious offense, the court finds a compelling state interest. And that's another area I just want to clear up for both counsel right now. When I'm reviewing what is a compelling state interest in continuing to prosecute and bring Ms. Fortune to trial. We're not talking about a compelling state interest in seeking treatment for Ms. Fortune, because there's a civil process for that. And that's something that's discussed extensively in one of the cases cited by defense counsel, Sell versus the United States. And in fact, in that case, the United States Supreme Court suggested that before the court seeks in a criminal matter to have competency restored, they should be looking at alternative grounds in the civil process to have treatment ordered if there's going to be involuntary medication issues. And if they haven't pursued that before pursuing involuntary competency restoration, the court should inquire why. Now, this is a little bit different issue in Sell because they're dealing specifically with a specific medication, whether or not it should be ordered to be, and we're not...
I don't take medication and I never will. I don't take pharmaceuticals.
Okay, thank you, Ms. Fortune.
That's not going to happen.
Okay, you need to let me finish, and then the attorney's going to have a chance to address that issue. But what the point in Sell, it identifies is that the civil process has different aims. It's designed to help reduce the dangerousness of people who might present a danger to themselves or others, or to help someone who's greatly disabled. That's what the civil process is for. And if these charges are dismissed, then there would be an evaluation done to see if Ms. Fortune needs treatment on those grounds. What the state is asking the court to do is to be treated so that she can proceed through the rest of the criminal process. And the court's determination is whether or not the state's interest in pursuing that criminal process is significant enough that justifies it. And so for serious offenses, the court's looking at the state's interest in getting an adjudication on that serious offense.
Serious offense is Mark Hubbard was murdered, hun, and
Ms.
Jeff Grosso
Fortune-
killed
Ms.
himself.
Fortune, it's not
And
your opportunity to speak right now.
And Jake Phelps killed himself. I mean, the Uri effect is real. It's been following me for 7 years.
Ms. Fortune?
Yeah,
Thank
I'm
you.
sorry.
It's not your opportunity to speak right now, okay?
I'm sorry.
So now I'm going to hear from counsel. As I said, I've read the briefing, and I'd like to hear if you have any additional oral argument that you'd like to present. It's the state's motion. So first I'll hear from Ms. Callahan.
Thank you, Your Honor. Really, everything the state wants to consider, all the criteria is in the state's motion. I guess the only thing I would add is as to whether or not trespass is a serious offense within the definition of harassment. I would agree that there exist trespassing cases that may not be serious even within the definition of harassment, you know, somebody crossing railroad tracks. However, the trespassing that happened in this case do fall.
No, I walked into Country Corner to get Farron's phone number to clear this up because Sean O'Brien is in on Mark Hubbard's murder, and I went in there and he started yelling at me that he was going to call Herb Crow. That's how this happened. I was illegally framed again for Mark Hubbard's murder.
We can't continue this hearing unless everybody has an opportunity
So
to
upset.
address the
I'm
court.
trying to keep myself
So you have
together.
to, I understand it's difficult, but you need to let the state address you, you let your attorney.
I apologize. I'm just so upset right now. I can't believe this is still going on. It's blasphemous.
Well, it's gonna be faster and quicker if
If I
we
be
get
quiet.
through it as quickly as possible by
Okay,
not
sorry.
interrupting. So, Ms. Callahan, you were addressing what the serious issue, before you do that, I just wanna point out and ask a question about the supporting documentation provided with the brief. The incidents referenced are not charged.
That's correct. So what the statute contemplates is that the court is required to consider things just beyond the incident's charge.
Well, I didn't see in the statute anything, well, it says, that I'll refer to the state brief here. The court should look at the criminal history, prior history and treatment, prior history of violence, which I believe the state said in the state's motion, none of these are violent, that they're harassing, stalking, cyber stalking type of.
They're harassing me. They're spraying me.
Not now. And, the quality and severity of the pending charges and any history would suggest whether or not competency restoration is likely to be successful. So I don't see uncharged, nonviolent incidences as being in any of those categories. So can you speak to that? What category is the court considering these under?
So, Your Honor, I guess the statement included those just because some of those incidents were borderline violent.
They were not violent. I was being assaulted. Sean O'Brien almost hit me. You weren't there.
Well, I guess I'm a little confused about the state's posture in this case, because I understand that there's a lot of different considerations that go into charging decisions. But what I've been provided is a series of police reports going back to 2018, describing a variety of incidents with a variety of levels of seriousness, a variety of threatening behavior, none of which have been charged. And the current pending charges, which are criminal trespass, first degree and second degree. Now, I understand some of it is providing the court some context for the criminal trespass charge, particularly with the skate park, provides the court a better understanding of the security to citizens issue with trespassing at the skate park, because a number of the incidents had to do with individuals at the skate park.
No. My friend Scott Stamnus, that's his memorial. And that's my friend. And Vulcum knows, his family
Ms.
knows.
Fortune, it's not your opportunity to speak.
Okay, well, I have a right to have that skate park be open and free for me to go and take pics if I want. That's my brother, my friend. That's his frickin' grave.
Ms. Fortune, it'd be helpful if you were able to make notes on a piece of paper about what you're thinking about right now.
I know. It just comes off the cuff because I'm so emotionally warped and deranged from this thing.
If you have things that you'd like to tell the court, you can write them down in a note.
All right.
And they'll work out.
Thank you. I'm trying to be good, Your Honor. I'm really trying. I respect you. I'm sorry. It's just been so traumatizing for me.
I understand, Ms. Fortune.
Okay.
So I understand why those particular instances will have been understand, but I want to be clear when I'm looking at the quality and severity of the pending charges, the state has not filed charges on these instances. Is there any?
That's correct, Your Honor. It would be better if we have more information rather than less. Many of them go to what underlies the trespassing in the charged cases. And so I provided that information for you to consider, both as the prior history of violence, how much weight you believe that it should be given, and then also the extent of the impact of the alleged offense on community for security for the citizens within the jurisdiction.
All right. Well, I do feel the majority of those reports would go, again, to the civil determination process about whether or not it's in misfortune's interest and the public's interest to deserve civil commitment versus competency for the pending charges. But I appreciate having more information, and certainly did provide more information on the context of.
Can I say one quick thing? I was let off probation years by Mareva Herndon and Judge Peter Cahill. They know that these guys are guilty for the murder. I mean, it's Maui, all of Maui knows. Like, when are these guys going to get busted?
We're not here on the Maui stuff right now, okay?
Okay, sorry.
Okay.
All right. So then, is there anything else that you wanted to draw the court's attention to, Ms. Kelly?
Your Honor, just what I was saying before, that while there is trespass cases that wouldn't fall under harassment, potentially this case does, based on the facts.
No, the facts are fraudulent.
Write it down and I'll look at it, okay?
All right.
Your Honor, the court seat all remains seated just so the microphones work.
That's fine.
I think it's significant that at the very start of this issue, back in December, there was an opportunity for any of the parties to know if they believed that this was a serious offense. And there were multiple hearings after the order was entered, where the issue could have been raised and an amended order could have been entered, indicating that there was a belief that this was a serious offense. And it was not until March 17th, which I believe is 97 days after the entry of the initial order, without any notice to the parties, without any notice to me, that the state was now taking the position that this was a serious offense. And I know that Ms. Fortune has had some difficulties with her courtroom decorum because of how she feels very strongly about some things in the past.
Thank you.
However, I'll let the court know that walking into this courtroom, Ms. Fortune last week was under the impression that there was agreement by the parties that the case would be dismissed.
Yes.
She would be referred to have a designated crisis responder interview her. And she was okay with that.
Yes.
But then, when the case was called on the record, she was given a very different message, and she was very upset. So I think that's some context for the court to understand what happened last week.
Thank you.
As we indicated in our motion, it's important for the court to take the definition of harassment into context. And State versus Joseph specifically asks or suggests that a court should look into the legislative history of Chapter 98.46 in determining whether an offense can be categorized as a crime of harassment. I think
Did you guys see the video on Mark Hubbard murder? Instagram, Mark Hubbard murder. You will see the incident where I was served on Jake's Celebration Day a $500 fine for Terry Rogers and Herb Crow. Do you know how heartbreaking that was on my brother who killed himself? I'm there to celebrate his life, and Herb Crow shows up with Terry Rogers with a $500 fine on my brother. Like, can you imagine what I've been through?
You gotta let me do my job.
You guys gotta give these guys a break. These are my godfathers, man. Be there for them. I don't even care about me. Let me out of here.
I can't help you when you're
This is just so fucking demonic.
This is what I do, okay? I'm here for you.
I've never broke down like this. I just can't do this anymore.
Ms. Roach, if you want to sit outside, you're allowed to do that.
No,
You're allowed
I
to
wanna
here.
be here. I'm just,
Okay.
I almost like cried. This is just, my heart is just so wounded, and all of Camp Orcas with me, you know, the whole island's with, this gotta be over.
I got this.
Okay,
You gotta let me.
I'm just shaking. I'm
This
gonna,
is what I do, all right? Look at me real quick. Look at me.
I'm trying to pull myself together.
Right? Okay? All right, we're good. Thank you.
Okay, so I just wanted to stop you because I do have a point that I thought was significant, that I'm not sure it was addressed in the brief. So, when talking about, so there's serious per se offenses, I think we all agree that something that's serious per se means the court doesn't do an independent evaluation of whether or not it's serious. The court still has an obligation, as described, to determine whether the state has a compelling interest, whether it's all these factors, but per se means that it's automatically going to be considered serious. And what the definition is in this statute is any crime listed in 9846 as a harassment crime, not any crime defined as a harassment crime. And I believe in the defense's own briefing here, the defense agrees that this charge is listed as a crime of harassment in 9846.
And I still think you have to use the fact that the difference in 9846 and the other statutes that I gave examples of listed crimes, definitions of types of crimes.
So I guess what I'm pointing out is
Permissive.
the difference in 1077 in the list of things that are considered serious per se. Hang on one second. Let me pull it up and have the actual language here. Because your argument is that there's a difference in the way that the different statutes define what is or isn't a serious crime or isn't a crime of harassment. And it says, any offense, any violent offense, sex offense, serious traffic offense, military offense, as those terms are defined in statutory citation. Any offense except the included in crimes against persons in statutory citation. Any offense contained in chapter 941, and then any offense listed as a domestic violence incident, domestic violence offense, any offense listed as a harassment offense. And so that choice of listed, can you speak to that choice of listed?
I still think despite that language, you still have to follow the reasoning of just because it's listed, I do not believe that every criminal trespass in a second degree case is automatically a crime of harassment and therefore a serious offense. That there needs to be context to the legislative intent about the harassment statute, that it is, that chapter is aimed at making unlawful the repeated invasions of a person's privacy by acts and threats which show a pattern of harassment designed to coerce, intimidate, or humiliate the victim. And so I understand your point that the word listed is used, but it's still permissive language in the harassment definition statute that says it may be a crime. And then it's not exhaustive. So if there is a repeated invasion of privacy by theft, which isn't listed, that could be a crime of harassment and therefore a serious offense under RCW 1077.
Well, except for it could be a crime of harassment, but it's not listed in chapter 9846.
But if it's still potentially,
How are they getting away
I
with
just,
this?
Your Honor, I don't think you abandon the analysis on what a crime of harassment is based on the language of listed in the RCW 1077. The idea that because that reading results in the possibility that every criminal trespass, including the examples that Ms. Callahan just gave of going onto some railroad tracks, walking through somebody's yard, they say, please leave my yard, you say, I'm not leaving, you've never met them before, it's not a pattern or anything like that. That wouldn't be a crime, that shouldn't be a crime of harassment, and it shouldn't abandon that analysis when looking at depriving somebody of a significant liberty interest of hospitalizing them for 29 days and forcibly giving them psychotropic medications. That just because we're now under 1077, we don't abandon the reasonable interpretation of the harassment definition statute, because that's the legislature's intent was to treat harassment crimes as defined differently. And so I think the legislature's choice of words with 1077 aren't intended to create a situation where every criminal trespass case, regardless of whether or not it's actually a harassment case, should result in it being labeled as a serious offense.
Well, my question then is, well, first of all, isn't that the whole purpose of having a serious per se section? Not that the court is abandoning all analysis, but it takes you on two different tracks for that analysis. And that serious per se means the court is not conducting an inquiry. This is automatically considered a serious category, and then you still have to conduct an analysis on whether or not competency restoration is appropriate given the facts of that particular case. But wouldn't you agree with me that that's the point of having a serious per se definition?
Yes, but my position is that when you are still being asked to analyze whether or not a crime is a crime of harassment as defined in the RCW.
Well, then my second question is, why should I go to the legislative history when the language of the statute is plain? I mean, they have section B under 1077, any offense except non-felony counterfeiting offenses included in crimes against persons in RCW 994 418 or 411. So the legislature is capable of carving out things they think aren't included. And they chose to they wrote any offense listed as a harassment offense, and again, not defined as, but listed as a harassment offense in chapter 9846. So why should I go beyond that plain language?
I was served that $500 fine for nothing. I want to say they showed up. I hadn't even done anything. This is fraudulent. I don't even have a reason they evicted me out of the skate park, and they know it. They made it up. I'm just letting you know, nothing happened. Out of nowhere. I was like, what? I didn't even know. Yeah. Okay.
Your Honor, it's my position, and it's my briefing that I still believe that there needs to be an analysis on whether or not a simple misdemeanor such as criminal trespass in the second degree is a crime of harassment. Otherwise, it's my position that we